Hello, this is Matt on the Moon Family Said Dan channel. Here's a headline from the Crypto Basic. Deaton says SEC engages in unconstitutional expansion of HOWEY test. So the SEC is flagrantly violating the law. And now that I, over the last 2.5 years, have become a securities attorney, I'm kidding. Of course, I'm not actually. It just feels like that for how much stuff I know more about securities law than I ever thought I would. And I understand that doesn't even technically make me close to an attorney. I understand. But I'm just a regular dude. Why do I know anything about securities law? This is stupid. So anyway, I just wanted to say, out of everything that I've learned to this point, it's become crystal clear. And this is me being as open and honest as possible, taking in perspective from attorneys that have opposing viewpoints and just honestly asking myself, hey, Matt, you're a really smart guy. Who is making the most sense here? I'm telling you, after viewing everything, it is crystal clear that not only are we on the crypto side here in the XRP community correct, but it's not even close. And so keep in mind, that's not me saying that Ripple couldn't get a technical loss. I think that's very possible, actually. I've been saying that for a very long time. But if we're talking in terms of the long-term viability of XRP, or as XRP itself as security, no. And so what we have here is an SEC that has no intent of pushing towards, striving towards what their actual stated mission is, which is investor protections and capital formation. Ask yourselves, what are they doing to achieve any of that? Well, nothing. So what we're actually having, and with the arguments and nonsense that the SEC is pushing for, it's, as stated by Attorney Deaton here, unconstitutional. And in fact, Coinbase chief legal officer, Paul Graywell, has stated that they're violating the law. That's how bad this is. It's a runaway, disgusting government agency, the SEC is. Absolutely terrible. So before going further, though, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so there's a tweet from Whale Chart that kicked this off a few days ago. And they wrote, just in, Coinbase's chief legal officer, Paul Graywell, says that the SEC is violating the law. Now, that's a big assertion, and I appreciate that he's being so bold to state that while the SEC is actually suing Coinbase. So I don't know where the hell that spine was 2.5 years ago. They're a bit linguini spine back then, but now they've got something that approximates an actual backbone. So, hey, we'll take what we can get, I guess. So Attorney Deaton retweeted that, and he ended up tagging Paul Graywell, and he said, is Paul Graywell engaging in hyperbole by claiming the SEC is violating the law? Let's review a few facts. Number one, up until 2018, the SEC had no policy whatsoever regarding SEC staff owning crypto because these digital assets were a new asset class, and the SEC was unsure about it. Number two, in 2018, when Hinman was drafting his infamous speech discussing digital assets in general and asserting Bitcoin and ETH were non-securities, senior officials at the SEC acknowledged that crypto assets fell into a regulatory gap, and it was unclear the SEC could even regulate. And so pause to think about this, the audacity of these little butt nuggets, claiming that Ripple should have known, and Brad Garlinghouse and Chris Larson, they should have known that what they were doing was illegal. To argue that, but then to know internally that they acknowledged that there was a regulatory gap thanks to the revelation of the Hinman documents and the emails, all that's now been released. It's a little gross, isn't it? Or maybe, it's a lot gross. It's absolutely disgusting. And then number three, Attorney Deaton says, in 2019, the annual FSOC report, signed by Jerome Powell, CFTC chair, Treasury Secretary, etc., highlighted the growing market cap of virtual currencies. The report highlighted Bitcoin, ETH, Litecoin, and XRP. Chairman Clayton also signed it without referencing U.S. securities laws. Well, that's a little peculiar, huh? You're just going to go ahead and sign that thing all willy-nilly? Former SEC Chair Clayton? Just, hey, it's virtual currencies. No little asterisks, no pushback whatsoever. It's not, hey, these things, by the nature of them existing, they're securities. Nothing even close to that. Just going to sign the damn thing. It's offensive on its face. Number four, from Attorney Deaton. In early 2021, Gary Gensler, testifying at his confirmation hearing, agreed that this regulatory gap exists and that there was no existing regulatory framework for crypto companies as it falls outside of the CFT and SEC frameworks. Yeah, and in fact, Gary Gensler, there is a video which has been pretty widely circulated throughout the XRP community, so probably a lot of you have already seen this, but it was back before Gensler was SEC chair. It may have been, I could be wrong, but I want to say 2019. But he literally specifically cited Ripple and how there specifically was not regulatory clarity for them. And I'm paraphrasing, but I promise you that is the message that he articulated on stage on video. And so for him to state, yeah, well, it still needs to be determined, and then he becomes SEC chair, and then to seem now speaking out the other side of his mouth, well, I believe that the law is very, very clear. Oh, shut the hell up. I am so sick of that Mr. Burns lookalike. Number 5, from Attorney Deaton. There isn't a single case in U.S. history finding that an investment contract existed between a promoter/issuer and a buyer when there exists no privity, communication, or relationship between said promoter and said buyer. Now, folks, to me, this is the nail in the coffin here. If you're talking about, now forget about Ripple, because again, I've already said, yeah, they could lose. I'm not saying they should or shouldn't, just set that aside. In terms of what XRP actually is, again, there's not a single case in U.S. history finding that a secondary sale of an asset, once utilized in an investment contract transaction, to also constitute an investment contract, all supplemental sales. So that means even if there was a law broken because somebody bought XRP from Ripple and Ripple did a no-no and there weren't proper disclosures, or there wasn't proper sign up with the SEC, all that crap. Well, if whoever bought that from Ripple then sells it to you, you have no contact with Ripple. That transaction wouldn't be any piece of that. And the SEC doesn't want to make sure the world knows that, even though they know it. They absolutely know it. That's why it's disgusting. They are harming the investors that they've sworn to protect. They are harming them by ensuring that there is not regulatory clarity. And they go so far as to, in court, say stuff to judges like they did in the library case of, yeah, well, that's not what we do. We don't talk. If somebody breaks the law, we just bring the. But we don't go stating that something isn't a security. We wouldn't proactively state that. That's the message that they were conveying. Well, what the hell good are you doing to investors then? Where are you helping the investors? Why are we all pissed off at you? Why? Because you've been harming us. You've been decreasing our overall net worth by harming the crypto space. That's what you've been doing. Really grinds my gears, folks. Number 7, from Attorney Deaton. West Virginia versus EPA decision. Supreme Court of the United States invoked the major questions doctrine, striking down the EPA's unauthorized expansion of its powers in the clear absence of congressional authority. Yeah, so folks, and I've been talking about this a fair bit lately. It's been discussed widely recently, in particular within the XRP community and covered by crypto media. So the major questions doctrine of paramount importance. Because what you're talking about here is this idea that if you're going to engage in some sort of legal maneuver, if you're a government agency, and it's going to have major consequences, whether it's for the economy or pick it, the environment, whatever it is, if there's going to be major consequences, then if you're going to push forward, then you, government agency, must cite where you've been given congressional authority to do so. And again, this comes from the Supreme Court. This is now law. The SEC obviously is engaging in tremendous governmental overreach. And so when you're talking about, this is what I keep saying, if this thing makes it to the Supreme Court, no, the current makeup of the Supreme Court of the United States is not going to put up with this stuff. And that's why it's kind of alarming, too. So there are 9 justices in the Supreme Court right now. And just be alarmed, because some people on the side of the party that's in charge right now, and you vote however you want. I'm just going to warn you, though. There have been some rumblings about adding justices to the Supreme Court, because you're not going to be able to remove the justice that these are lifelong appointments. But there's been rumblings about, let's try and add justice. Now, what might that do? Well, what if they add several more justices? And I'm not even saying whether or not this is or isn't likely. I'm just telling you what the types of people that are in charge right now are looking to do, and they've already harmed us enough, haven't they? What if they got their way and there were more justices on the Supreme Court? What if that actually happened? Now, that would be very short-sighted, of course, because the opposing side would always just use that in return, which is why it's best to just have the laws operate within a level playing field. But if you're going to add that, and then you're going to stack the courts with people that think a certain way politically, yeah, well, if that happened, obviously that would harm, I'd argue, every crypto holder and every XRP holder out there if things got to the level where a decision was being made there. But if you're talking about the current makeup of this, no. But that's why I'm saying, like, elections have consequences. So do whatever you want to do. I'm only going to talk about, anything political as it pertains specifically to crypto and finance. I'm never going to be preaching to you, but these are things that you should be thinking through. This could have direct impact on your net worth. Like, should such things unfold, just be aware of it. That's all I'm saying here. But I'm absolutely opposed to stacking courts in that way. Then the attorney Deaton said, the Supreme Court of the United States opinion in Nebraska also citing the major questions doctrine, striking down another agency's unauthorized use of power. And then he shared some comments from Paul Graywall, Coinbase chief legal officer. And so he wrote, I've read, reread, and reread the major questions doctrine holding in Nebraska at pages 19 through 26. Swap out secretary for chair, digital asset for student loans, and there is no conclusion but one. The SEC's interpretation of investment contract violates the law. Actually, it's far worse. The economic and political significance of falsely claiming authority over all digital assets other than Bitcoin is not just staggering, but untethered to the fundamental requirement that there be enforceable rights between enterprise and purchaser. Sounds right to me. Attorney Deaton continues. The Senate and the House have proposed legislation dealing with crypto assets and who and how Congress wants them regulated. The bills take the regulatory authority out of the SEC's jurisdiction or limits the SEC role in regulating crypto. One bill once fired Chair Gensler. Number 10. Even the executive order signed by President of the United States seemed to favor the CFTC and not the SEC. Conclusion. Paul Graywall is not being hyperbolic by claiming Gensler and the SEC are violating the law. The SEC is engaged in an unconstitutional expansion of HOWEY. It is so absurd of an unconstitutional expansion that it would retroactively make oranges sold by grocery stores securities. Think about that. And he's right. He's right. That's why I'm laughing, because it's absurd. If the SEC got their way and this became precedent, then grocery stores today, your local grocery store in the United States, selling oranges, it would be the case that they're selling securities. That's what this would do. We're living in upside down land, folks. But look, I'm still optimistic that what should be done shall be done. So let time pass. We'll see how it plays out here. And I'm not, as far as the stacking the courts thing, I'm not some sort of doomsday guy. I'm just saying this is a concept you should be aware of. If there's any real push, then we'll start talking about it in crypto communities, because it would just be disgusting and like that would be so far out of what would be. I don't want to go too far of a tangent, but just from just as an American myself, if any political party engaged in court stacking, I would be repulsed and I would want them out of power. I don't care which side. So, because I understand what that means. You're gaming the system at that point. We know what that means. Trying to take over the courts by changing effectively the rules, because that's what it would be. So again, I'm not saying that's what's going to happen, but when I see some people say that we should be doing that, I'm just like, wow, you're a gross human. Absolutely should not be doing that. Absolutely not. And again, I'm just talking about it in terms of what it would mean for we here in the world of crypto. It'd be bad if it went that direction. Food for thought. Again, I'm not saying that we're at a place where we should actually be worried about that imminently happening or something like that. But squash this stuff before it becomes a significant threat. You know what I mean? Spread the idea this is awful and it's not right. And then once even if they got their way, understand like they're going to be, they feel like, so they're the beneficiaries of such things if they're in charge and they make this happen. What happens when they're out of power though? Well, then they're not going to like it as much. That's why it's so stupid and childish. Because it's going to go, so it'll be for them while they're in power, and then when they're out of power, because it always flip-flops back and forth, it always has, then they're not going to like it so much. So why don't we just not do it? How about that? How about we just not do that? That would be fantastic. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.